Buenas noches a todos. Sean todos bienvenidos. El Centro de Arbitraje e Industria de la Construcción y la Universidad Iberoamericana les da la bienvenida. Tanto las personas que están aquí físicamente con nosotros, como las muchas personas que están por live stream, que quiero agradecer y reconocer y mencionar brevemente. Empiezo por, en forma importante, la FIC, Federación Interamericana de la Industria de la Construcción, que reúne a 19 cámaras de construcción de Centro y Sudamérica. De Perú, los colegas del Centro de Arbitraje de la Cámara de Comercio de Lima. De Colombia, el Centro de Arbitraje y Conciliación de la Cámara de Comercio de Bogotá. De Montevideo, el Centro de Conciliación y Arbitraje, Cámara Nacional de Comercio y Servicios del Uruguay. De Chile, el Centro de Arbitraje y Mediación de Santiago. San José de Costa Rica, el Centro de Conciliación y Arbitraje de la Cámara de Comercio de Costa Rica. De Guatemala, la Comisión de Resolución de Conflictos de la Cámara de Industria de Guatemala. De Asunción, el Centro de Arbitraje y Mediación de Paraguay. Y nuestros amigos de Houston, Monterrey, Baja California, San Luis Potosí, Cancún y Guadalajara, bienvenidos y gracias por estar presentes por vía remota. De las muchas actividades que hace CAIC para diseminar el arbitraje, la que definitivamente más orgullo nos da es la Conferencia Magistral José Siqueiros. Es la cuarta conferencia que hemos organizado y es una conferencia que fue creada para diseminar una idea que logra un ideal. El ideal es el Estado de Derecho y su importancia. La idea es la utilidad del arbitraje en lograr ese ideal. Para hacerlo, lo que CAIC ha hecho ya durante 4 años es que ha hecho una convocatoria pública cada enero a varios practicantes del arbitraje que incluyen la crema innata del arbitraje, muchos de los cuales veo aquí, bienvenidos. Y de los nombres que se proponen, se hace un cónclave de personas y se discute, se delibera quién va a dar la Conferencia Magistral José Luis Siqueiros el año que entra. El objetivo es recordar y reconocer a nuestro querido maestro José Luis Siqueiros, que es el evangelista del arbitraje en México, y en honor a ese carácter y a su memoria, reconocer un practicante de actualidad de quien queremos, además de reconocer, aprenderle. Y este año la votación arrojó a Maître Yves Fortier. Estamos muy agradecidos, Mr. Fortier, por haber aceptado la invitación. Yves me ha permitido que lo presente en español, además entiende algo de español. Y quiero también agradecer todos los trabajos que este año hicieron CAIC, vía su órgano consultivo, su consejo directivo, y muy en particular Orlando Ocio, que está aquí con nosotros, que es el nuevo secretario general, se los presento. Denis Reyes, que está acá afuera, y Jorge Osnaya también, que han hecho, junto con las labores de órgano consultivo y consejo directivo, de CAIC una institución. El plan que tenemos es que Maître Fortier va a hablar alrededor de 40 minutos. Quisiera pedirles que mantengan sus preguntas hasta el final. Luego son bienvenidas sus preguntas en más o menos 20 minutos. Y luego los invitamos a todos al Villa María, que está a 3 cuadras de aquí y cuya dirección, es más, la dirección la digo al final, a tomar un aperitivo y a platicar con todos los practicantes. Muchas gracias.
Muchas gracias, Francisco. I have a few words here that I would like to deliver in your beautiful language, which unfortunately I do not master as well as I wish I did. Estimados colegas, queridos amigos, es un gran honor y un gran privilegio para mí ofrecer este año la Conferencia Magistral José Luis Siqueiros. Debo decir sin lugar a dudas que pasar unos días en el caluroso México en enero no fue lo único que me convenció de aceptar, sino al placer de conocer e intercambiar experiencias con la comunidad de arbitraje de México en materia de arbitraje internacional. Agradezco al señor Francisco González de Cosio, abogado en la firma de González de Cosio, and presidente del Centro de Arbitraje de la Industria de la Construcción, por su amable invitación. Entiendo que esta conferencia está siendo transmitida en directo a otros países de América Latina. Saludos también a ustedes, mis amigos. El poder de la tecnología, el poder de la tecnología para conectar a la gente nunca deja de sorprenderme. Dear colleagues, dear friends, estimados colegas and queridos amigos, it is with great honor and distinct privilege that I accepted to deliver this year's Conferencia Magistral José Luis Siqueiros. I must say that it is a particular privilege for me to be here this evening. Just a little over a month ago, Wednesday, 10 of December, is the United Nations International Anti-Corruption Day. And the headline on the first page of Canada's leading newspaper, the Globe and Mail, read as follows on that day, and I quote, "Little to celebrate on UN's International Anti-Corruption Day." The article referred to a report on bribery issued the previous week by the OECD, which shows how wide and deep the tentacles of corruption extend around the world, across both developed and emerging markets. After reviewing data from 427 bribery cases over the past 15 years, OECD analysts reached the following startling conclusion, and I quote, "Corporate leadership is involved or at least aware of the practice of foreign bribery in most cases." This conclusion runs against the grain of the notion warmly embraced by embattled senior executives, particularly in the Western world, that overzealous rogue employees are responsible for sullying their company's sterling reputations. The OECD report is replete with some frightening statistics. Let me quote just a few of them. Bribes averaged nearly 11% of the total value of the contracts examined and almost 35% of the profits. The average size of the bribe was close to $14 million. Imagine the economic cost of corruption in the world. In Brazil alone, which was singled out by the OECD, a 2010 study pegged the cost of corruption at between 1.4 and 2.3% of GDP. In my own hometown of Montreal, a commission of inquiry on the awarding and management of public contracts in the constructions industry, set up by the government of Quebec, concluded, after listening for 3 years to the evidence of construction and engineering firms, that municipal contracts for the paving of roads, refection of sidewalks, and similar works added at least 30% to the value of those contracts. During the inquiry, the mayor of Montreal resigned in disgrace, and the mayor of Quebec's third largest city, Laval, has been accused of gangsterism. Where, may you well ask, is the link between corruption and arbitration? I will try to demonstrate to you this evening that when we, arbitrators, uncover a factual matrix tainted by corruption, when we enter the treacherous territory of bribery and illicit agreements, even though we may well find our loyalties challenged, we must not shy away from using the power which the parties have given to us. Yes, corruption puts the arbitrator at the crossroads of his allegiance to the parties, on the one hand, to party consent, and the arbitration agreement. and his allegiance to the international legal order, to his role as guardian of good morals in international trade, to what some, like our friend Pierre Lalive, fortunately passed away last year, call transnational public policy. The prospect of this choice and its consequences has led arbitrators to tread, in my view, much too cautiously. We do not need to look very far to find evidence of this attitude. Think of the paucity of arbitral tribunals that expressly deal with corruption. Think of the scarcity of awards where corruption was outcome determinative. And think also of the many procedural excuses, such as the requirement of a heightened standard of burden of proof, relied on by so many tribunals to avoid deciding issues of corruption altogether. This is evidence, writ large, in my view, of arbitrators who have understated their responsibilities to the international community's commitment to control corruption and give international law a bad name. And we, arbitrators, have no choice but to re-examine our position unless we are prepared to accept the not-so-veiled accusations that international arbitration is a safe harbor for corruption, an accusation that ultimately could add yet another layer to questions about the system's, our system's legitimacy. In other words, if we wish to provide the international legal framework governing corruption with an effective enforcement mechanism, we must find a way to reconcile both our loyalty to the parties and our adherence to the international legal order as conjured by international anti-corruption treaties. We need to reconcile the tension between these opposites and address squarely issues of corruption. After a very brief review of the international condemnation of corruption, I will detail the serious shortcomings of the current control mechanisms and what role we as arbitrators must play in order to palliate these shortcomings. I think it's absolutely vital that we first remind ourselves to what incredible degree states have now reached a consensus on the condemnation of the bribery of foreign officials by individuals and companies, what is also known as transnational corruption. It is not my remit today to review all the international efforts and international treaties adopted to curtail corruption. In the context of international arbitration, this has already been done, undertaken exhaustively by many eminent jurists whom many of us know, our dear friend Pierre Lalive, Michael Riesman, Louis Lamzon, and many others. A reminder of the more salient initiatives will suffice to demonstrate the extent to which the anti-corruption sentiment is shared amongst members of the international community. The 1997 OECD Convention on combating bribery of foreign public officials in international business transactions was the first international multilateral anti-corruption instrument, and it marked the real beginning of the international anti-corruption campaign. A number of regional anti-corruption treaties were entered into around this time as well, the most noteworthy being in 2003 the adoption of a comprehensive and near universal international anti-corruption treaty, the United Nations Convention Against Corruption. The convention is ratified today by over 160 states, and it is symbolic of how corruption is now recognized by the international community as a serious impediment to economic and social development and a global problem that requires collective action beyond national borders. The OECD Convention was modeled after the United States Foreign Corrupt Practices Act, which was adopted after the Watergate scandal and meant to constrain the payment of bribes to foreign officials by U.S. entities. However, and this is the point that I want to stress, it sought to constrain transnational corruption by acting only on what I would call the supply side of corruption. It focused on the individual that is offering, that is paying the bribe. The UN Convention, on the other hand, recognized that corruption, by definition, involves two parties: the bribe payor, the supply side of corruption, and the payee, the public official, receiving or soliciting the bribe, what is generally termed as the demand side of corruption. Now, in order to constrain transnational corruption, action on both sides of this equation is obviously required. Now, there can be no doubt that the adoption of these international instruments was a great achievement, but we need to recognize how much still remains to be done in order to curtail transnational corruption. And the limits of these international instruments need to be articulated and explained in order that we may find mechanisms to address these limits. And we, international arbitrators, I submit, have a vital role to play in the process. Now, the major shortcoming of international anti-corruption treaties has been their lack of enforcement mechanisms at the international level. I start with the OECD Convention. The Convention only provides for domestic enactment of anti-corruption legislation and for an advisory system of monitoring and peer review. It does not set out any international enforcement mechanisms. Enforcement of the Convention's provisions is left to national legislation and national courts. Nearly all of the other anti-corruption conventions operate in the same way. Leaving enforcement to national institutions, in my view, particularly in states where corruption is rampant, will result, of course, in an uneven application of anti-corruption legislation. A number of arbitral awards have already elucidated this fact. I commence with the often quoted and well-known World Duty Free versus Kenya award, where the tribunal noted that when Kenya was presented with evidence of bribe solicitation by its former president, quote, no attempt had been made by Kenya to prosecute him or to recover the bribe in civil proceedings. A similar issue arose in Wina hotels in Egypt, where the tribunal concluded that given the fact that the Egyptian government was made aware of this corrupt agreement, but decided, for whatever reason, not to prosecute Mr. Kandel, the tribunal is reluctant to immunize Egypt from liability in this arbitration. Why, I ask, why are states reluctant to adopt effective international enforcement mechanisms to sanction corrupt public officials or companies? And why should the international community rely exclusively on national legislation? You know, in a seminal volume on bribery, my friend, and you're a friend of many of you in this room tonight, Michael Reisman, after having reviewed the wording of these conventions, attempted to provide an answer to these questions. And he used the principles of the myth system and the operational code to describe the dynamics of bribery. According to Michael, in the myth system, all the rules and prohibitions against corruption, such as those in the UN Convention, are clearly expressed. The operational code, on the other hand, clarifies when and how these rules and prohibitions should apply. And what states say about corruption may actually be very different from the conduct that they consider acceptable. In other words, and very simply put, whereas states applaud international anti-corruption instruments, they're very skeptical when the time comes to enforce their public commitments. In recent years, a number of suggestions have been made to introduce a universal system in order to enforce these grand anti-corruption principles. For example, the World Bank, in collaboration with the United Nations, put forward the idea of an international anti-corruption forum. This forum was meant to provide an international arbitration mechanism allowing for decisions on the commercial effects of corruption and bribery. But to this date, discussions about this would-be forum remain inconclusive. The establishment of either a court or an arbitral tribunal that would review public sector contracts and international commercial transactions in order to identify corruption has also been recommended by some academics and other people of other ilk. But these proposals and suggestions have come to naught. This should not prevent us, however, I submit, from searching and identifying mechanisms to control transnational corruptions outside of these grand anti-corruption conventions. An example of a successful mechanism that I know well is the World Bank Group's sanction system and its sanctions board that I have chaired. I've had the privilege of chairing since 2012. In 1996, the then president of the bank, James Wolfenson, in the now ubiquitous metaphor, characterized corruption as a cancer and firmly set anti-corruption policies on the World Bank's radar. And following these remarks and a number of reports, the World Bank's anti-corruption policy was adopted by its board of directors in September 1997. Now, the more salient features of this policy were the incorporation of anti-corruption provisions directly into lending decisions and the condemnation of fraud and corruption in projects and programs financed by the bank. Now, a sanctions process was devised to sanction companies and individuals engaged in fraud and corruption. The end game of the process is the debarment of corrupt contractors from World Bank finance contracts. Debarment means that a corrupt contractor is disqualified, either temporarily or permanently, from any bank finance contract. And in order to frame the process which could lead to debarment, a mechanism for investigating fraudulent and corrupt activities was established, which today falls under the purview of the World Bank Group's Integrity Vice Presidency. INT conducts witness interviews, makes site visits, gathers documents in the course of its investigation into the activities of companies and individuals. And an evaluation and suspension officer then makes an initial determination whether the evidence presented by INT is sufficient to conclude that a sanctionable practice has been committed. And we have at the sanctions board level, we have a de novo review of the case with memorials, a hearing, testimony of witnesses, arguments by counsel. In other words, a true arbitration. And the sanctions board, publishes fully reasoned decisions on liability and appropriate sanctions in each case, which increases both the transparency and the deterrent impact of the sanction system. Through its diverse membership, the board today, not only a Canadian, but also a South African, a Brazilian, an American, a Senegalese, the sanctions board has been able to draw on a variety of legal traditions in its own practice and development of its case law. And the process has proven very effective to identify and deter wrongdoers, and on the other hand, to release those who may have been wrongly accused. The World Bank is not working alone. Cross-debarment and harmonization efforts with other international financial institutions strengthen the impact of the World Bank sanction system. At present, there are over 650 firms and individuals on the World Bank Group's public debarment lists. Now, the World Bank system, my friends, provides an example of an efficient tool to tackle corruption. And the question I pose is whether the system, in particular its investigation method, its hearing process, could serve as a template for international arbitration. The World Bank has walked the talk. It has not only hailed the grand anti-corruption principles of international instruments, such as the OECD and the UN conventions, it has acted and put in place an effective mechanism to enforce and eradicate the cancer of corruption. And noticeably, it has adopted a standard and burden of proof, which, while respecting due process, allows for the fair prosecution of firms and individuals who very often resort to opaque and obscure methods in order to engage in and conceal fraud and corruption. And what about corruption in international arbitration? Well, I refer, of course, to both commercial and investor-state arbitrations. And at the outset, I state that in both investment treaty and commercial arbitration, evidence of suspect intermediation agreements, also known as contracts for corruption, and contracts obtained by corruption will occasionally surface. It is the presence of the state in investment treaty arbitral proceedings that can make that particular form of dispute settlement a potent tool for positive and effective control of transnational corruption. Have states in these cases been held accountable by tribunals for their public anti-corruption commitments? I ask the question to all of you. Many of you here are senior arbitrators, members of the international arbitration community. The general condemnation of transnational corruption and the international instruments adopted to reflect this condemnation in recent years are not foreign to international arbitration tribunals. As we know, in 1963, Judge Grenmar Lagergreen, in a seminal statement, wrote in an ICC award that, and I quote, "Corruption is an international evil. It is contrary to good morals and to international public policy common to the community of nations." Recent cases have made explicit reference to modern international anti-corruption treaties. 2006, the World Duty-Free Kenya Tribunal stated, and I quote, that in light of domestic laws and international conventions relating to corruption, and in light of the decisions taken in this matter by courts and arbitral tribunals, this tribunal is convinced that bribery is contrary to the international public policy of most, if not all, states. More recently, in October 2013, the Metaltech and Uzbekistan Tribunal, on which my friend Klaus von Bobesser sat, and I will return to that case later, after stating that, and I quote, "the international community of states has sought to address the issue of corruption with a targeted effort to eliminate corrupt practices in the public service sector and criminalize corruption in domestic legal orders." It then proceeded to examine many of the international treaties to which I've referred earlier. However, and I come back now to the dichotomy which I mentioned at the outset of my lecture, despite the often repeated respect that arbitral tribunals display for international anti-corruption instruments, tribunals have in fact been very, very reluctant to engage and deal with cases of corruption, adopting an attitude that can be assimilated to private skepticism. There is a manifest reticence on the part of arbitrators, as convincingly demonstrated by Lamzon in his recent treaties, to act on evidence of corruption when it raises its ugly head. As a result, all too often, if corruption is alleged by either party, it is rarely outcome determinative. As I said earlier, positive findings of corruption in international arbitral decisions are very rare. And tribunals will very often avoid making a positive finding of corruption by insisting on a heightened threshold for proof of corruption beyond that of a balance of probabilities, or by declining jurisdiction. Antonio Crivellaro, in a study 10 years ago of international commercial arbitration cases that dealt with corruption, found that in most cases tribunals required a very high standard of proof. Recent cases have not reversed this trend. In a recent FIFA arbitration, a panel of distinguished CAS arbitrators, notwithstanding what appeared to someone like me who had not participated in the hearing as overwhelming evidence of corruption, dismissed allegations and charges of corruption, concluding that the standard of proof to be applied in this arbitration is that of comfortable satisfaction, which FIFA had not met. You're probably aware about the ramifications of that decision. Crivalero's conclusions find echo in the practice of investment arbitration tribunals. In EDF Services versus Romania, the tribunal stated the seriousness of the accusation of corruption demands clear and convincing evidence. It also determined that there was a general consensus amongst international tribunals and commentators regarding the need for a high standard of proof of corruption. Heightened standards of proof will, of course, make a finding of corruption very problematic, as corruption is notoriously difficult to prove, and direct evidence is not often available. It is not surprising that in the two cases where a positive finding of corruption was made, the corrupt conduct was admitted in one, the World Duty Free versus Kenya, and in the other, the tribunal, on its own, investigated the indicia of corruption, the Metaltech decision. Some tribunals have also avoided dealing with matters of corruption by simply declining jurisdiction. In International Systems and Controls Corporation versus the Industrial Development and Renovation Organization of Iran, the Iran-U.S. Claims Tribunal, after allowing for the delayed submission of evidence of corruption, declined jurisdiction and did not rule on the evidence submitted. In a strongly worded dissent, Judge Brower, again known to many of us, argued that the tribunal's palpable reluctance to grasp the nettle of alleged imperial corruption in Iran has led it to choose a graceless jurisdictional exit. Dixit Charles Brower always finds the right words. Why, I ask, are arbitral tribunals reluctant to investigate corruption? Should arbitrators engage actively whenever indicia of corruption surface without punishment, without concerning themselves with consequences to the parties' expectations? And what about the situation where, tempted though they may be to investigate sua sponte indicia of corruption in the record, corruption has not been pleaded by the parties? In order to extract arbitrators from a paradigm modeled on state attitudes of private skepticism and operational codes vis-à-vis the control of transnational corruptions, arbitrators need to seek a degree of harmony between their allegiance to the parties and their allegiance to the international community, rather than choosing to be bound by one commitment over another. Interestingly, Professor Lon Fuller, I was referred to his treatise on the morality of laws recently, he refers to the difference between the morality of duty and the morality of aspiration. Fuller explains that the morality of duty consists of applying the basic rules without which an ordered society is impossible and whose transgression leads to punishment. And the morality of aspiration, on the other hand, is the morality of excellence, of the fullest realization of human powers. A failure to realize it does not lead to sanctions or punishment, but rather to a failure to achieve excellence. For example, a doctor must obey certain minimum ethical requirements and strict duties. But a good doctor aspires to exceed these minimum rules. He aspires to achieve more. He strives towards excellence beyond those minimum requirements. And morality of aspiration includes ideals and principles beyond the strict minimum. According to Fuller, these two moralities are a continuum. They represent an ascending moral scale. I begin at the bottom of the scale. with the morality of duty. At this bottom point, the scale would include, for instance, the rules and duties of the arbitrators, as set out in the applicable arbitration rules and the arbitration agreement. As I ascend the scale, however, at some point, the morality of duty ends, and the higher demands of the morality of aspiration begins. And this is where I place, currently, the international community's universal condemnation of corruption. I say currently because these different moralities can often morph into one another. As rulings and decisions addressing international corruption become more prevalent in arbitration, international anti-corruption norms become more concrete. They take the shape of rules and decisions which enter within the domain of morality of duty, but soon gain in obligatory force. Of course, the arbitrator, you, I, must be keenly aware of his duties to the parties, to the entities that have entrusted him or her with their dispute. But he also aspires to certain ideals of international justice and morality. There is no real choice to be made between these two moralities, at least not if the arbitrator, like the doctor, wishes to excel in his practice. He must compose with and adopt both of these commitments. Allow me to conclude with a more practical answer by giving one example where arbitrators have, in my view, demonstrated commitments required to effectively denounce and investigate corruption. The recent award in metal tech and Uzbekistan, to which I've referred a couple of times, provides an illustration of how ideals about controlling transnational corruption can be channeled into an active but harmonious investigation of corruption. The Metal Tech Award was rendered just 14 or 15 months ago, in my view, is remarkable for several reasons. I didn't know you would be here this evening, Klaus. The Metal Tech Award, in my view, is remarkable for several reasons, no less for the fact that it is the first investment treaty case where corruption proved to be outcome determinative. The tribunal was chaired by the well-known Swiss arbitrator, Gabriel Kaufmann-Kohler, and the eminent Mexican arbitrator, Klaus von Bobisser, who was a member of the tribunal with John Townsend. The tribunal's analysis of corruption was based on consultancy agreements signed between Metal Tech and 3 Uzbek consultants. The tribunal suspected the illicit nature of these agreements when a number of new facts emerged during the hearing. And first, it received an amendment to earlier consultancy agreements on the record, which described the consultants as being primarily engaged in lobbyist activity. Second, the tribunal learned that the consultants were compensated by payments totaling approximately US $4 million. Excuse me. In light of these new elements, the tribunal acted, in its own words, ex officio, as neither party had raised allegations of corruption, and issued a procedural order requesting the production of additional testimony and evidence regarding the agreements. The tribunal's finding that the agreements amounted to corruption in violation of Uzbek law was based notably on adverse inferences and the analysis of several red flags regarding the consultancy agreements that it opined were determinant to the outcome of the proceedings. Now, the approach taken by the Metal Tech Tribunal in investigating corruption should be seen in terms of Fuller's moral scale, as the continuum which I described earlier between the morality of duty and the morality of aspiration. And this continuum provides a legal and practical lens through which we can envision the arbitrator harmoniously tackling matters of corruption. At the top of the scale, At the morality of aspiration, we can place a decision in Metal Tech, the decision by the Metal Tech Tribunal to begin investigating corruption. The pursuit of an investigation, particularly when neither party has alleged corruption, requires fortitude and belief in the arbitrator's mission to the international community. And this is particularly true in view of the level of uncertainty and indeterminacy typical of corruption investigation, because, again, as we all know, evidence of corruption is often difficult to find in the record. I do not mean to argue that arbitrators should go on fishing expeditions in search of corruption. We must be prepared to face uncertainty and even surprises when we investigate a factual issue such as corruption that is, by essence, difficult to establish, to quote the Metal Tech Tribunal. As we move down the scale, we find loosely defined procedural tools whose use will require a degree of commitment to the international anti-corruption campaign. Drawing upon circumstantial evidence is a good example of such a tool, and the Metal Tech Tribunal relied on circumstantial evidence, on so-called red flags or indicators of corruption, which provide arbitrators with a number of factors which any adjudicator with good common sense would consider when assessing facts in relation with a corruption issue. Without necessarily leading to a clear finding of corruption, these red flags may point to areas where that require the tribunal's attention. And as we continue downwards, inching closer to the morality of duty, we come to procedural tools requiring less commitment while being more constraining, such as adverse inferences. The Metal Tech Tribunal listed several examples where the claimant was asked to provide evidence of services rendered by the consultants but failed to comply with the request. And it drew from this a number of inferences, noting that and I quote, the inference that inexorably emerges from this dearth of evidence is that the claimant can provide no evidence of services, because no evidence of services, or at least no legitimate services, were in fact performed by the consultants. In this context, I note that the International Bar Association rules on the taking of evidence in international commercial arbitration provides for the drawing of adverse inferences when one party has failed to cooperate with an order by a tribunal. Now, these inferences may be critical to reaching a sufficient threshold of proof in matters of corruption. And as we reach the bottom of the scale, we find ourselves within the purview of the rights and duties prescribed by the morality of duty. And this is the territory of such unassailable principles as due process. Again, the Metal Tech Award is illustrative of an investigation conducted with regard to the due process rights of the parties. Throughout its investigation of corruption, the tribunal gave both parties the opportunity to make submissions on the issues of corruption and requested on several occasions additional submissions, the production of testimony and evidence. My friend, an arbitrator in the process of dealing with a factual matrix where corruption exists travels along the entire scale of Fuller's morality. He harmoniously integrates the aspirations of the international community engaging in an investigation when suspicions of corruption arise, using procedural tools that require variable degrees of certainty and commitment to the international anti-corruption campaign, while having due consideration for his duties and the rights of the parties through the respect of such unassailable principles as due process, fairness, and impartiality. I hope that in the future, all of us, international arbitrators, carefully weigh this message when we have to deal with issues of corruptions. We should not be afraid to use the power which we have, which the parties have entrusted to us. If we do have awesome powers when we accept to serve on international arbitration tribunals, we must not, as I said at the outset of my lecture, shy away from using that power, even though we may find our loyalties challenged. But we must always do so harmoniously. We do have an important role to play in combating one of society's dominant scourge. Muchas gracias. Thank you. Thank you. As Francisco, thank you very much. Muchas gracias. As Francisco told you at the outset, I'd be happy to answer any questions which you don't think I've already answered in my text. Please feel free to ask me any questions in French or in English or in Spanish. Yes, please.
First of all, thank you very much for your presentation. Very interesting and very detailed. My question deals with the risks that arbitrators also face when the arbitration process itself is taken advantage of with some corrupt intent. And although I have not participated nor been close to an example, I have read about these situations where the arbitration process is taken advantage of with a goal of a corrupt result. And an example is a case where a claim is brought against a state government or state government agency. There's a very timid, unsubstantiated response, and shortly thereafter there's a request for the tribunal to make an award based on a settlement reached by the parties. The objective being, of course, that the arbitrators express in an award a settlement that has been reached, which settlement has nothing else but the fruits of an agreement, probably even pre-agreed among claimant and the governmental agency or the state. I've read about the situation, at least in one occasion, where the ICC, Court of Arbitration, failed to approve an award reached by agreement precisely because the arbitrators had communicated to the court the fact that it was suspicious of such conduct. I don't know if you can address this, because this is a very serious risk to the reputation of arbitration itself.
Well, no, it's very difficult for me. I'm not familiar with this set of facts that you've presented. It's very difficult for me to say other than the following. We, arbitral tribunals, as we know, are product of the parties' agreement. The parties' agreement is usually embodied in an arbitration agreement or terms of reference or what have you. And they delimit to a large extent the parameters of the tribunal's authority, of the tribunal's remit. And if, to pursue with your example, if the parties at some point in the course of the proceeding reach a settlement, the claimants and the respondent, in your example I thought you may have been referring to the state being a respondent, but I don't know. But if they reach a settlement, much as you would have liked to dig in and to inquire into what is behind the factual matrix over here, do exactly what the Metal Tech Tribunal did. in the Uzbekistan case, if they produce a settlement agreement, you don't have any choice. You don't have any option. You don't have any. You're not privy to the evidence which they referred to one another, which they shared with one another, and which led both parties to say, well, let's settle this on that basis. It's. But I would be. I know, and I touched on it in my paper. I know that there are cases out there, and yeah, I realize that this is being broadcast, but I think everything that surrounded the FIFA events of recent months and recent years, and you must know what I'm referring to, and which led to a case being appealed to the Court of Arbitration for Sport. And as I said, I read I did not attend the hearing. I did not hear the witnesses, but I read the transcript. I read the decision, and to me, it not only looked like bribery, it not only smelled like bribery, it was bribery. And they said, well, we're not comfortably satisfied. I respect, there are three very distinguished arbitrators who sat on that panel. It's, I expect that the respondent in that case probably walked away from that hearing after he learned of the decision saying, I got them. Oui, madame.
You mentioned that some people have a problem that is persistent is that states sometimes do not take action regarding officials that could be involved in corruption.
Yes, the state itself.
Yes, exactly.
Before the arbitration surfaces.
In general. Exactly. What a situation, and let's just take as a possible situation an arbitration in which the state has taken action against the government officials for allegations of corruption in a transaction, and at the same time intends to take action against the private individuals. And
the bribe payor.
Exactly.
Yeah.
Exactly.
Mm-hmm. Sure.
But you have the arbitration ongoing. So you would have basically local proceedings, on both levels, and yet disputes pending in a different forum.
I think in that decision, Gabriela, in that situation, I think one of the two, and I expect it would probably be the arbitral tribunal, would suspend the hearing until the termination of the domestic proceedings, and then say, okay, now come to me with a record of, I presume, a condemnation. But I don't think that both. I don't think that both tracks could go along parallel courses. I really can't see it. One would have to say, we hold off until you terminate the proceedings here. And now, Klaus, are you going to tell me what I missed in the Metal Tech Award?
No, absolutely not. I tried to not talk about the awards I was involved in. No, I have a question. What do you think about this new theory that is evolving around this type of cases, where you have the shift of burden? And let me put an example. If you have a case where there's a strong suspicion, and somebody brings some evidence where you can get some inference that maybe there was a wrongdoing, that then the tribunal can say, okay, now the burden has to shift to the other side, the one that did the wrongdoing, to prove that whatever happened, and then bring evidence that whatever payments or they were legitimate. So, because often, as we know, and as you correctly state, having a direct evidence is almost impossible. I mean, in this case where clearly there was quite strong evidence that where you could infer the corrupt payments, but you don't find those always, because in this case, and actually Metaltech presented all the evidence, as you correctly stated, all the contracts, to whom it was paid, everything, but that's not often the case. So having the system of the shift of burden in a situation like this, what do you think about
I know it well, because this is precisely what happens before the sanctions board. The INT, the integrity vice president, has the burden of demonstrating on the basis of it's more likely than not. It's more likely than not that the corporation or the individual engage in fraudulent acts or acts of bribery or what have you. And then the burden shifts to the respondent to demonstrate that no, they did not. And they have the same standard of proof applies, more likely than not. So I'm all for it. I'm all for it.
And quickly, a brief comment about Eduardo's question, and this is with my head of Vice President of the ICC Court of Arbitration. The rules of the ICC precisely have, when the tribunal has the right to approve an award by consent, it establishes that it's the right of the tribunal, not the obligation, precisely for the reason that Eduardo stated. Since there has been cases where arbitration has been used for those legal purposes, the tribunal can refuse giving an award by consent precisely for that reason.
Yes.
That's the reason of the rules that have that
I see.
that provision. Simply
Thank you.
Mention because there have been cases, unfortunately, in the practice of the ICC with those characteristics where not so much the court have refused to approve, but the arbitrators have refused to issue the award by consent for that reason.
Ah.
Indeed, the court supports the decision of the arbitrators. The risk here is that, as I was mentioning earlier, the tribunal and the arbitration process is abused, because with this intent of reaching a settlement with corrupt background is simply to have a justification of an award blessed by the ICC or any other administrating entity that would allow the state government, state agency to make payment of an amount. So, here's the payment. I was forced to do it. This is an award that was issued. It's registered. So I had no other option but to make payment. When, of course, there was no justification. Perhaps there were no services or no construction being made, or not to the extent
that could give a very bad name to international arbitration, as I said in my remarks. Yes.
Where, on one hand, carry on the case. You have a state entity. The state entity has leading functionaries. They do things they're not supposed to do. The state entity takes criminal actions against these functionaries. But the main, the issue might be, or it seems to be, actually these functionaries somehow act ultra vires. That means they're doing things they're not authorized to.
The rogue employee defense, the rogue functionary.
Yes.
Fonctionnaire.
So how would you handle this? Would you attribute their acts to the state, or would you consider it as something separate? Because
I turn to Francisco's treatise, and I look at page 354, and I find the answer.
I owe you some royalties.
No, this is a serious question, and of course, and you know, it takes two to tango. Of course, it takes the supply side and the demand side. It takes two to tango, and if the state, I mean, many of you in this room are even more knowledgeable than I am about, you know, to what extent can the state blame its rogue functionaries and say they were acting outside their terms of reference, so the state is not responsible. That is, I'm not exaggerating, that can be the subject of a treatise in itself. And you know that. You've written... I don't know. It's one of those... I remember when I was not an arbitrator but counsel, and I had a client who, after listening to me saying on the one hand and on the other hand, he said, you know, one of these days I'm going to get a one-handed lawyer representing me. So there are many. On the one hand, there are cases where the state has been successful, and there are cases where the state has not been successful. Alejandro. Oh, sorry. Oh, sorry.
Yeah, Mr. Fortier, I fully agree with your position in connection with the way in which arbitrators should address bribery and corruption in a more, just to say, liberal way, not necessarily finding direct evidence, but more or less basing their decisions on common sense and presumptions. But I am a little bit concerned about the enforceability.
About the enforceability?
About those kind of awards. Why? Because if we put bribery and corruptions are in every legal system, I would say, crimes. And obviously an arbitral tribunal should not and cannot declare a crime. And that's the difference between having the direct, strong evidence and what an arbitral tribunal
You're right.
must decide.
We are not criminal tribunals.
Of course.
No, you're absolutely right.
And there is also this other tendency, for instance, in Mexico, which is very in vogue, about human rights and the presumptions of innocence. And somehow, talking about the FIFA case, I would say that they kind of took that approach.
Which case?
The FIFA case. They were not really convinced. They do not have the direct evidence.
No.
And somehow they apply this presumption of innocence.
Well, which is more of a criminal notion than a civil notion.
And that's maybe the difference and the way to handle it.
Yeah.
We are dealing with commerce.
Good point.
And in commercial bribery and corruption, let's put it a rule like that. Maybe presumed, and that's it.
And they use the words, we're looking for clear and convincing evidence which will make us comfortably satisfied. I have a view on that too, but because it's not a sports offense. I'm talking about FIFA the FIFA case is a very special case, but generally the athletes who are charged before Court of Arbitration for Sport tribunal are not facing a criminal charge, but they're facing very serious accusations which can lead to disqualification and the end of a career. But the standard of proof is comfortable satisfaction. It is not beyond a reasonable doubt. It's comfortable satisfaction. Sorry.
Yves, thank you very much for your lecture. It was very, very interesting. And I was a little bit afraid when you started saying that corruption is rampant in everywhere. Supply side, demand side, and then you more or less focused on governments, public tenders, corporations. Who is more to blame, he who gets the pay or he who pays? to get the contract. But then when you go into the cases, we all realize that apparently corruption is outside of the realm of arbitrators. And I just wanted to sort of confirm with you, because we understand that a lot of people have more trust in the arbitration system than perhaps in the judicial system, which is part of the government's. And although many judges are absolutely honest, there may be some feeling that in some countries corruption goes into the judicial system.
Indeed.
We have not heard or even suspicious of arbitrators being corrupted.
Fortunately not.
And I just wanted to sort of hear from you, in a magnificent career of many, many years as an arbitrator, if you could share that feeling that in the arbitration community, the word corruption is kind of for something else, but not for the arbitration process in itself, and obviously not to be applied to arbitrators.
As I've heard all too often, thank you for the question. Because it gives me a chance to reply to it in a way that I did not consider should be mentioned in my lecture. What about the corrupt arbitrator? Obviously on a no-name basis, but I have done a couple of arbitrations where I have become convinced after a while that this is really the exception. I'm talking about a minuscule, a minute number of cases, but where I became convinced that, as chairman, that one of my fellow arbitrators was disclosing to the party that had appointed him or her what was going on when the doors were closed and the members of the tribunal were deliberating. And I have, I have wondered. I've asked myself, what do you do? Do you first of all, these were both institutional tribunals, do you disclose on the basis of what you suspect? You don't have hard evidence. Do you disclose to the institution that you suspect that one of your co-arbitrators is not acting in an appropriate way, thus derailing the whole process and engaging in these are real questions that I ask myself. Maybe some of you have faced the same situation, and at the end of the day, since there was going to be a majority award anyway, I chose not to do anything about it. I'm not proud of it, but I'm speaking very, very frankly. I guess the principal question is, how are you going to prove this? You go to the Secretary General or whatever of the institution, and you say, so and so, I suspect that he's like a sieve. He's conveying to the party that appointed him. I remember in one case we were deliberating. This is the same case, and our colleague was asked to give his views on question A, question B, question C, and he was taking notes. What the other arbitrator, what I was saying, was taking notes. Sometimes he would make us repeat. What did you just say? Okay. And he didn't volunteer any answer to the questions. went away, back home, and a few weeks later we got answers to question 1, answer to question 2. I have not the slightest doubt that those answers came from the party that appointed. I haven't got the slightest doubt. Could I have proved it? No. I could not have proved that. So I decided, but that's corruption. Of course, that's corruption. That is corruption writ large. But I can assure you, in both those cases, neither one of the I haven't seen. Good English here. I haven't seen either one of those 2 arbitrators surface ever in another case. For what it's worth. I don't know, maybe you have war stories. I'm sure you do have war stories. I tried to answer your... we It's very difficult.
Unfortunately, several of us have stories similar to yours, sometimes with even less happy endings.
That's possible.
And the less happy ending I refer to is not that you are able to issue a majority award, but in one instance in which I participated, and I was convinced that through very timid approaches with the other arbitrator, with the other, let me put it for lack of a better word right now, with the other clean arbitrator, you know, just as if you were fencing, we started to say, well, don't you think it's a bit curious? And at the end we were talking about it's what our colleague is doing is totally unethical. He's corrupt. We were convinced. We even put a little bit traps, and those traps were bitten. You know, a little. The other arbitrator took a bite, and we were able to confirm that he was disclosing information and deliberations to other parties. Unfortunately, in that case, and that's why I have a very bad taste of that case and a corrupt situation, is before we were able to issue an award, even though deliberations had been carried out, even though an award had been prepared to be issued by majority, when they received notice by the parties, the joint communication saying they had reached a settlement.
Oh, really?
The settlement was submitted to the tribunal, and we realized that the amount agreed was less than the amount that the tribunal was ready to issue the award. So,
lest there be some misunderstanding, I wish to stress that in 99.9% of the cases where I have had the privilege of serving as chair, after a few months I forget who appointed who, on the tribunal, and that's and I mean that. I forget. So that's the happy side of of the practice. So thank you very much.
Can I ask?
Oh, you yes.
Well, first of all, thank you for a very, very interesting presentation. You've given us a very sophisticated tool for a problem that many of us have put our minds to, and that we hadn't come to a conclusion. I, for one, look to reading your paper when it becomes published, because I'd like to fully understand how to use that tool. And in contrast to it, what I like about my initial reaction is that what I like about it is that it seems like a much more thought out and sophisticated approach than what we currently see in many other cases. We have cases all over the spectrum. Some tribunals hiding behind no jurisdiction. And I say this because there's a line of cases that I know, that you know, that I know, that are that take the approach that when faced with a corruption or other forms of illegality, the tribunal drops jurisdiction like they would as if they had grabbed a cup of hot tea. And I've always felt, and you articulated very elegantly, what that does is bestow a benefit on the side of demand side corruption. And it's always, in that example, the investor who bites the bullet, even though it would not have been able to do a project absent doing something. So that, not that I praise that the investor did that, but it didn't seem like a very thought about solution. Your solution seems much more adroit. But I wonder whether it doesn't beg a question, which is the following dilemma. When you lower the standard, like the FIFA case you mentioned, from beyond a reasonable doubt to comfortable satisfaction or to other standards of evidence, you run the risk of false positives. So I wonder whether using tools like circumstantial evidence, but that's, again, you run the risk of false positives, might be another thing to consider within that tool, or it might be the solution in the manner that Marco Tulio suggested and Klaus, to the issue of, well, there's been an allegation, a serious, not just a tactic, a serious allegation of corruption, so we want to hear each side's version before we rule upon it. And finally, do you propose that that technique be used every single time, or only when its outcome is positive?
I don't think it needs to be outcome dispositive, but I would be more inclined to use it if I had satisfied myself that it would, bring one result as opposed to another. Yes, but I don't think it needs to be. Okay. Time for a glass of wine?
It is. Thank you all very much.
Thank you.